Kaiser. I'm going to turn it over to you. Looks like my clock says 12 noon.
Well, thank you, and howdy, ladies and gentlemen. I want to spend about an hour today talking with you about Texas water and Texas water law. It seems when we get into a drought, there's a greater urgency and a greater awareness on the part of the people of Texas, on landowners, on elected officials, on policymakers, and on the general public on water, its importance in their life, and the rules of law that have evolved in this state to allocate and protect water resources. So, what I would like to do today is take you through three key points. I want to talk a little bit about Texas water sources and uses. In other words, where do we use water in this state? Where's our surface water? Where are our groundwater resources? And how do we use them? I want to talk also a little bit about the history of Texas. Indeed, you can look to our basic history and find our water rules and water systems integrally tied to our history. And this has led to the third point on the laws that we have in Texas related to surface water, to a subject called diffuse surface water, which is rainfall and snowfall that falls on your property, and it's your property while it's on your land, except that if it flows into a river, then it belongs to the state. If it percolates into the ground, then it belongs to you. So the third topic we'll talk about is groundwater. So sources and uses of water, our water history, and how this history has led to the laws that we have today governing surface water, diffuse surface water, and groundwater. This chart that you're looking at, I tried to graphically portray on our sources and uses of water. And if we look at aquifers, if you're looking at this chart, and hopefully you can see my scroll bar that's going along, aquifers in Texas, almost 2/3 of all the groundwater that we pump comes from one aquifer, the Ogallala Aquifer, located in the Texas Panhandle. On the right side of this chart, these are the sources of our surface water in rivers and reservoirs. And when you look at the pie chart in the middle, the amount used, about 60% of all the water we use in the state of Texas comes from groundwater and about 40% from surface water. The groundwater that we use in Texas, 80% of that is used by irrigated agriculture in this state. So as we've thought about the evolution of groundwater law in this state, it has a direct and important impact on agriculture. When you look at how we use surface water, cities and industries use most of our surface water, and agriculture the remaining amount. So this gives you a general perspective on sources and uses. And the next few slides will contain a bit more information. So estimates last year, we used about 17 million acre feet of water. For those people who aren't familiar with the term an acre foot, it's the amount of water to cover an acre 1 foot deep. I like to tell people, think of a football field and cover it with 1 foot of water, and that's close to an acre foot. It's about 326,000 gallons of water. So you can see 17 million acre feet multiplied by 326,000 gallons will give you an idea of how much water we use in Texas every year. Of this water, 60% comes from groundwater, this 17 million acre feet. And groundwater, as you see this symbol CR/GCDs, groundwater is privately owned, but it's subject to two rules. It's subject to the capture rule, the CR, and the rules of groundwater conservation districts. Surface water comprises about 40% of this 17 million acre feet. And surface water is owned by the state and allocated by the Texas Commission on Environmental Quality. So we really have these two water worlds: groundwater, which is privately owned, surface water, which is publicly owned. In terms of our major users in the state of Texas, agriculture uses about 60% of all the water consumed and used in this state, and that's about 10 million acre feet. Most of that water is used by irrigated agriculture. Within this agriculture category, it also includes ranching, but ranching uses a very small portion of this. The other, about a third of the water we use in this state, and this amount is growing every year, is used by cities and industries. The other amount, about a million acre feet, is used by mining and other activities. So again, looking at groundwater, which is very critical for agriculture, 80% of all the groundwater we use statewide is used for irrigated agriculture, and about 20% by cities. Just about the flip side is true for surface water. 65% of the surface water we use is used by cities and industry, and about 35% by agriculture, predominantly irrigated agriculture. I'd like to talk a little bit about surface water supplies and just give people some factoids about how fortunate we are in this state to have a huge amount of surface water. If we measured all our river miles, if we laid them length to length, we've got about 190,000 river miles. That's the equivalent of taking all our river miles, stretching it. It would go around the equator about 2.5 times. We have 15 major river basins in this state, and then we have some smaller coastal basins. So our major river basins would include the Brazos River, for example, the Red River, the Colorado River, the Rio Grande, the Sabine, the Neches, the Trinity are examples of our major river basins. I've always been fascinated as I travel through Texas when you cross these major creeks and streams and rivers. Our TxDOT, Texas Department of Transportation, has done a wonderful job of putting up named rivers. We have almost 12,000 different names of rivers and streams in Texas. One of the curious things, we tend to name our rivers for animals, trees, but not vegetables. So except for Onion Creek, which is in Austin, we don't have many rivers named after vegetables. We have Peach Creek, Cherry Creek, Mustang Creek, Old Woman Creek. So we name our creeks and streams after a variety of individuals, but not much in the way of vegetables. For surface water, because the state has been granting water rights, there are a little over 6,000 corporations, cities, industries, and individuals that own water rights in Texas. However, when we think about the major surface water in this state and ownership of this water, even though it belongs to the state has granted permits or permission to use it. 90% of the surface water rights in this state are held by about 200 water rights holders. And I've got a chart later that will depict the Trinity River and the major water rights holders on the Trinity River. And we use about 7 million acre feet of surface water. It varies from year to year depending on rainfall and drought. One of the interesting things in Texas is a way to deal with drought, because rivers don't always run at the 12 months of the year, 24/7. One of our strategies to provide water to industries, to individuals, to people in this state is to build reservoirs, large dams. Today, we have some 195 reservoirs throughout the state that hold more than 5,000 acre feet of water. However, most of the surface water in this state that we store, 95%, is held in just 75 reservoirs. And I have a chart that will show the location of these reservoirs. Now, one of the things on surface water that's critical for people to understand within these 15 major river basins that we have, because for the last 100 years, the state has been granting permits for people to use this water. 12 of these 15 river basins are fully appropriated. That means there's no more water for individuals in that river if everyone that we've given a water right or permit to pump water, divert water, if they use their full right, there's no water for anyone else. And this has real implications for water management in this state as we continue to grow. Our surface water supplies, I like to tell people, and it's a truism, surface water just doesn't fall in a civilized fashion in Texas. When we get rain, we often get rain in huge amounts. And when we don't get rain, we could go a month or two without much rainfall and things get very dry. So in part to deal with these variabilities, the state has built these reservoirs. And on these 15 major river basins, you can see on this chart, I've outlined the number of reservoirs by river basin. So the Brazos River has 43 dams and reservoirs on it. The Canadian 3, the Trinity at the bottom of this list has 31. Now you can see from this chart, I was going to make this Aggie maroon, but it came out kind of pinkish. It really should be Aggie maroon. But 50% of all the storage of our reservoirs in Texas are held in these three river basins, the Sabine, the Neches, and the Trinity. I like to tell people you can think of this state divided in a couple of ways. Think of Interstate 45 running from Dallas to Houston. This is our wet part of the state where we get more rainfall than other parts. When you get west of Interstate 35, rainfall decreases. So think about this. Anytime you look at a chart that shows rainfall patterns throughout Texas, you will see the Beaumont-Port Arthur area may receive 60 inches of rainfall. By the time you get out to El Paso, it may be 6 to 8 inches. I tell people my general rule is for every 100 miles you go from east to west in Texas, rainfall decreases by about 7 inches. And so our surface water, most of our rainfall and storage is really in East Texas. This map depicts the 75 major reservoirs in Texas that store 95% of our water. So look at these dots in the western part of the state, particularly the Panhandle. The dot just below the Texas border, the second dot below the Texas border with Oklahoma is Lake Meredith. It is basically dry today. It was constructed to provide water to 11 cities in the Texas Panhandle, everywhere from Lubbock, Amarillo, down to La Mesa. Because there's no surface water, these cities had to rely on groundwater. So you can go to the Water Development Board website, generally look at all these dots representing reservoirs west of Interstate 35. You will see that today they may hold anywhere from 3 to 5 to less than 50% of the total storage. When you get east of that area, you look at the reservoirs in East Texas, they're close to being full. They're holding 70 and 80% of their built storage capacity. So it really reveals we get a little more rain in East Texas, we can store water. Once we get to West Texas, oftentimes in these reservoirs, more water evaporates each year than we use. So again, this is the point on these 75 major reservoirs. 95% of all our storage is in these 75. And this graphic just depicts if we were able to capture all the runoff in the state of Texas On an annual basis, we have an average about 50 million acre feet of water run through our rivers and streams and discharge ultimately into the Gulf. We have the capacity to capture about 40 million of this 50 million acre feet. But when we get in a drought, because these reservoirs evaporate, our dependable yield in a drought is about 15 million acre feet. And this chart depicts 2000. This last year, we used probably 7 million acre feet. On groundwater supplies, again, some factoids here. 60% of all the water we use statewide comes from groundwater. We have 9 major aquifers that supply 90% of all the groundwater we use. An interesting point, the Ogallala supplies 2/3 of all the groundwater used in Texas. And this is a critical resource for agriculture as well as the cities in the Panhandle. However, groundwater is really critical throughout the state. So I have a map later that will show 134 of our 254 counties in Texas. More than half of the water used in those counties comes from groundwater. And a pattern at the bottom, groundwater transfers to cities are really increasing, particularly along the I-35 corridor. So this is a map of the major aquifers of this state. So obviously in the Texas Panhandle, that's the Ogallala. For those of us who live in central Texas, the red area is something called the Carrizo-Wilcox. For those of you in and around San Antonio, your major aquifer is the Edwards and the Trinity. For the people along the Gulf Coast aquifer. So if you look at this, most of Texas is covered by a major aquifer. By the time you add in minor aquifers, there are very few areas of the state where people don't have access to groundwater. When we look at how much water people are using on an aquifer basis, this is a chart I put together from different versions of state water plans. So the portion lists the aquifers, the Ogallala, for example, the Edwards, Carrizo, our major aquifers, then the other aquifers. So totally we use about 10 million acre feet a year. This will go up and down again depending on rainfall. The chart or the figures on the right again are taken from the most recent state water plan that estimate the availability of water that can be extracted from these aquifers. So we're taking about 10 million. The planners estimate that there is about 13 million. However, in an aquifer like the Ogallala, which doesn't recharge rapidly, in other words, nature through rainfall or snowfall, not a very little amount of water percolates back into this aquifer. It's called a fossil or a very old aquifer. Basically, as we pump this amount of groundwater, we are basically mining this aquifer. We have other aquifers that recharge rapidly, such as the Edwards. So for those people who live in and around the Edwards, you certainly know based on the monitoring well that the weather reports in and around San Antonio, they always list the water level of the monitoring well. With 1 or 2 good rainfalls, that monitoring well comes up very dramatically. So that aquifer rapidly recharges. So many of these aquifers, while we may get 20 inches of rainfall, only 1 or 2 inches of water of that rainfall actually percolates back into that aquifer. And it may take 100 years or 200 years for it to percolate into the depth where we can use it. So while they do recharge, it oftentimes is a very long time scale before they recharge. This map is a map of Texas where you see that the blue on it, these are counties that rely more on groundwater than surface water. And there's some interesting patterns here. So you can see in West Texas, where water evaporates, if we try to hold it in a reservoir, it evaporates very rapidly just because it's hot and dry. So counties in West Texas for agriculture, cities rely extensively. But if you look at those counties along the Rio Grande, particularly in the lower Rio Grande Valley, they rely extensively on surface water provided either by the Rio Grande, the Pecos River, the Devil's River, or the Rio Conchos, or some of the smaller tributaries that feed into this. So these areas rely on surface water. What's interesting when you look at East Texas, and I've always found this to be an interesting phenomenon, you would think East Texas, which has plenty of rainfall and surface water storage, look at the amount of water that comes from the groundwater. And there's a relatively simple explanation. It's about cost and availability. So if you want to rely on a river and you want to transport water 4 or 5 miles from that river, that's expensive. It's more expensive than putting in a well and pumping water for your city or for your own use. So this is really an interesting phenomenon. It's tough to say we have one set of rainfall conditions in Texas or one set of uses in the state. We really have variability in the amount of water that we use. So before I start on the 3 eras of Texas water law, are there any questions that anyone has about where our water comes from, how much we use, and different use patterns throughout the state?
Dr. Kaiser, there's one question from Fred, and the question is, how much of the municipal use is for the urban irrigation?
You know, there are interesting patterns. We have studied how much water is applied to lawns. Generally, in East Texas, the amount throughout the whole year is probably east of 35 to 40% of total residential use is applied throughout the year to the lawn. However, during the summer, when we don't get as much rain, it can be as much as 50%. In College Station, based on studies that we have done here in College Station, my graduate students and I, up to half of the water applied from April through September in College Station, more than half the water is applied outside the home on lawns and swimming pools. When you get to West Texas, again, it depends. It can be a much greater amount, but many homes in West Texas or west of Interstate 35 may have smaller lawns. People just discover it takes a lot of water.
And to our participants, if you have any questions, feel free to type them down there in the chat pod at the very bottom, left-hand corner, and Dr. Kaiser will be glad to answer your questions. That's the only question so far.
Okay, well, again, let me just elaborate on this because there's a great deal of discussion as we think about total water use in Texas. And there's this whole notion of conservation. What we really see are the major areas for saving water and conservation to apply water more frugally are for homeowners, for residential properties, commercial properties in cities to apply the water within a water budget, to apply only that amount of water that the lawn needs and not overwatering. Based on our research in College Station, we find there is significant overwatering. So the city of College Station, we are trying to provide information to homeowners to advise them on when to water and when to turn off their irrigation systems. For agriculture, we know there are certainly opportunities for more water conservation. So these are the 2 areas that have generated pretty significant interest in conservation, and there are opportunities for great water savings in these areas. If there are no other questions, let me move to these 3 eras of Texas water law and history. And I think we really have 3 different phases or eras that we've gone through in this state. We've had an era of development where we have allocated our water, where we've built reservoirs to deal with growing needs. And we hit a second period where we became awakened to, well, maybe we can't build our way out of the demand for water. Maybe we ought to start thinking about conserving water. And the most recent era that we're in is an era of reallocation. And when I think of that, I mean moving water from agricultural uses to urban and industrial uses. And that's one of the consequences of growth. We're proud of growth in Texas, but growth comes with a consequence. And this is really apparent on the Colorado River in Texas. It's apparent to rice farmers who rely on water from the Colorado to provide water for their fields. As we've been in a drought and as we've had huge increases in population over the last 30 years in and around the Austin Metroplex, and I say Austin Metroplex, extending just about from almost San Antonio all the way up to Georgetown, tremendous growth in this area. And these areas have relied on surface water. And so the Lower Colorado River Authority has allocated and provided more water to satisfy this urban growth. And so there are real consequences to growth in terms of water availability. So let me spend a little bit of time talking about these three eras, which lead into then surface water, diffuse surface water, and groundwater. So in our development era, from about the 1880s through about 1990, when we look at surface water law in Texas, we started in about 1840 adopting something called English common law. It's called riparian water law. And under these rules, if you owned property that touched a lake, river, or stream, you had a right to use water on your land, but your right had to be a reasonable amount. Beginning after a drought, a significant drought in the 1880s, Texas began changing its rule, going to this system called prior appropriation. And I'll explain more about what that doctrine means. During this time period, we also began establishing river authorities. And today, we have river authorities on most of our major rivers and some of our minor river systems in this state. The first river authority was the Brazos River Authority, established in 1928. The point I'd make here, during this time period, the clear preference of the Texas legislature was to manage surface water on a watershed basis. And these river authorities were established to do that. What also drove the change in the law during this time period is drought. And I have said to many people, drought has bad consequences, but one of the benefits of drought is it gives us the political will to make changes in the law to deal with population growth and drought. So I tell people, never waste a bad drought to bring about changes that you need to change. So we had droughts in the 30s, certainly the 40s, the 50s were our drought of record. We had some drought in the 90s, and most people point to the drought of 2011. At least on our recorded record, we say this was one of the worst in our history. And not surprisingly, we have made major changes in our law as a result of that drought of 2011. As a result of drought and pumping of groundwater, the legislature established groundwater districts, and our first district was established in 1951. Today we have some 99 different districts in this state, and we made significant changes in our law in the 1960s after the drought of the 50s. You know, interestingly, if you look at water planning in this state, we really didn't start significant statewide water planning. We did local planning, but not statewide. After the drought of the 50s, our legislature established a water agency and gave them authority to do water plans. Today, it's the Water Development Board. So we have plans that were in 61, 68, in the 80s, the 90s, 92, 97 was a pivotal year. That was the year through the leadership of Lieutenant Governor Bob Bullock. We fundamentally changed the way we did water planning in this state. We moved from having the experts in Austin do the plans and then send them out to this regional planning process we have today. So we have a plan in 2002, 2007, 2012. I have read all of these state water plans, and I have come to one conclusion. I need to get a life. The other thing that we've seen in water planning and involvement of the state, in 1957, the legislature authorized a referendum to be approved by the people of the state. And in 1957, the voters in Texas approved $200 million in bond funds that the state could sell to provide loans to communities to develop water systems. One of the items of the state authority here is when we sell bonds in the state of Texas, we can sell bonds oftentimes at a lower rate than communities. So what the state is doing is they're basically acting as a bank. And we sell bonds, local communities borrow money then based on those bonds, and they repay the state, and the state repays these bonds. This is a form of debt in Texas, and we have significant debt because of these bonds. So in 57, we started this first program. Just this last legislative session, our legislature passed the State Water Infrastructure Trust Fund to provide grants to communities to continue to build infrastructure. One unique thing about this last session, and voters approved this in a referendum last November, was to take $2 billion of surplus that we had in our state treasury and allocate it to this fund. That was very different because up to this time we had always borrowed money to build. This time we took money that was excess from the rainy day fund, and voters approved putting up to $2 billion in this fund. So what really has driven this is drought. So during this time period, again, in development, when we look at construction of reservoirs in Texas, and this bar chart indicates, yes, we had some in the 1880s through 1900s, but after the drought of the 50s, you can really see from 50 to 60, some 40 reservoirs were constructed in this one decade. In the decade of the 60s to the 70s, nearly 15 reservoirs were constructed. And once we hit that high point, we then built fewer and fewer and fewer reservoirs. Why? Because we began to look at the cost, because we had built a number of reservoirs, because the cost increased, and because voters began to look at other ways to provide water to the residents of this state, namely through conservation and reuse. So this, again, depicts the drought of the 50s in Texas. And again, if you look at some of these conditions and you look at the number of reservoirs that we had in Texas through the 40s, we only had about 50 major reservoirs. By 2000, we were up to over 200 major reservoirs. Now that number, and these are reservoirs that store more than 5,000 acre feet, that number has been reduced over the last 20 years because a number of these reservoirs are getting silt. They're filling with sand, which means they don't hold as much water. And so that's leading to some reduction in our reservoir storage capacity. Our second era is really the conservation awakening. From the 1980s to the 1990s, you can look at some key indicators. So in planning, in the mid 80s, all of our water efforts were in an agency called the Texas Department of Water Resources. The legislature had this agency go through a sunset review. And as part of that, the legislature decided to break apart the Department of Water Resources into the Water Development Board, and their first was the Texas Commission on Environmental Quality, or the Texas Natural Resource Conservation Commission, which today became the Texas TECQ. We had a plan during this time period that said, let's build more reservoirs. If we look to the law, we began to say, oh my gosh, we could totally dry up our rivers if everyone uses all the water. And what about our bays and estuaries? And what about in-stream flows, the environmental values? And so in 1985, the legislature passed a rule that said for any new reservoirs constructed after this time period that are within a certain distance, a certain amount of water has to be set aside. During this time period, the legislature also said, you know, we ought to start requiring our cities and public water suppliers and private water suppliers to prepare conservation plans to look at how can we conserve water. And interestingly enough, the legislature put on the ballot a question to create a conservation fund for farmers, to provide grants to farmers, not grants, I'm sorry, low interest loans to begin to conserve water. Well, surprisingly, farmers would rather have had the money given to them, and irrigators did not take advantage of this, even if they were low valued loans. And so there were very few loans made out of this program, and ultimately the bonds sold were wrapped into other bonds. So the learning from this is, yes, if you provide loans to farmers, even though they may be willing to adopt conservation, because they operate on small margins, they oftentimes cannot pay to pay off these bonds and loans. In terms of water use, the high point in Texas in irrigation water use was in the 70s, when we used about 13 million acre feet. Since that time, the total water use statewide for irrigation has been declining, and all the plans point to continued decline in this state. And not surprisingly, because of rapid population growth, municipal use has increased tremendously. Let me just put this somewhat in perspective. In the drought of the 50s that many people point to, which was our severe drought, we had about 9 million people. Today we're at 23, 24, 25 million people, and we're one of the fastest growing states in the nation. You can see if we repeat a decadal long drought that we had in the 50s, and we had all these consequences with 9 million, it will be pretty economically devastating for Texas, and the bulk of the economic devastation will fall on the backs of agriculture. And so starting in the 1990s, as a result of planning, as a result of greater engagement from a variety of stakeholders, we came to the realization that we can't build our way out of this issue. We will never build enough reservoirs to satisfy everyone's all the water they always want, even under drought. And so the planners, the legislature began to say, we've got to look at other options and get serious about this. And so we got serious in terms of requirements for water conservation. We began to look at transferring water from lower valued uses to higher valued uses. And indeed, cities and industry have been doing this. We began looking at reusing water, taking water from our wastewater treatment plants, we call them sewage treatment plants, putting that water on our landscapes, on our parks, on our medians. We began using of this in agriculture for forage crops. To today, the city of Big Spring and the city of Wichita Falls are seriously taking water directly from their wastewater treatment plant right to their water treatment plant. We call it direct reuse. we built a number of reservoirs for other purposes, and now we're looking at reallocating some of that water for flood control or hydropower, reallocating it to municipal or industrial use. And we began talking seriously about desalinizing brackish water. During this time period, the legislature created the Edwards Aquifer Authority. Senate Bill 1 in 97 totally reconfigured the way we do water planning. So no longer are the experts in Austin preparing all the plans and sending them out. We now rely on planning at the local level, and all of these plans then are consolidated by the Water Development Board, and we get a state water plan. That's really a consolidation. So we've really flipped this process. And we've established more groundwater districts. And we established this State Water Infrastructure Fund. So let me stop at this point before I go into Texas water laws and ask if there are any questions.
Yes, sir. Larry Perez asked a question. His question is, has any type of research done on water consumption by the oil and gas industry? Here in the Eagle Ford, it's amazing how much water is used by oil and gas.
Excellent question. As a result of, and this is the operative term, hydraulic fracking, that means we're using water to break apart oil and gas formations that we've discovered through new technology how to do this, particularly in our shales, which are very dense formations. They hold oil and gas, but in the past, if you drilled into it, because they were so tightly packed together, they weren't very permeable and porous. And so with hydraulic fracking, we can break these formations apart and we create all these cracks in them, and we try to keep these cracks open so the oil and gas that's stored in there, the natural gas, can now go to our pipes. In addition, we've developed a technology to not just go straight down, but to drill out horizontally 3 and 4 and 5,000 feet, which really allows us to tap these reservoirs. To do this, we have to have water. Up to this point, the easiest form of water is really potable water, water that we would use for drinking from the Carrizo-Wilcox Formation. To frack and break open some of these formations, it may take 6 to 12 acre feet of water to do this per oil and gas well. And so in the Barnett Shale, in the Eagle Ford Shale, because there's so much activity going on, when you look at the water allocated statewide to these two new oil and gas development opportunities in Texas statewide, it's minuscule. But when you look just within these areas where these geologic formations are, it may constitute 8 or 10% of the total water use. Interestingly enough, if you think about growing an acre of rice, it takes about 4 acre feet to grow acre feet of water to grow that acre of rice. If you have 2, that may be up to 10 acre feet. That's the same amount of water that it takes to frack one of these oil and gas formations. And when you look at the economic rate of return from that, economically, you can see why people will sell water rights to companies that are doing fracking, because they will make more money in selling their groundwater to these companies than they will trying to irrigate a crop. But it really begs the big question, if we pump all of this and once it's gone, what will we do in the future for water? And I tell people, you can oftentimes live without oil and gas, but you cannot live without water. So these are really critical questions that we have to have a serious conversation about.
Yes, sir. John asked a question. Is it legal to capture and use rainwater?
Yes, except in Colorado. And so I'll talk a little bit about this under diffuse surface water. So John, if you could just hold off on that question, I'll get to it.
And the next question is from Larry. He says, but the water the farmers use goes back into the hydraulics cycle. Oil and gas water is then contained and cannot be reused.
You know, that's a myth. When you grow corn and you irrigate corn, and that corn uses it, and it uses most of it, when you sell that corn and export it, you're exporting your water. So you really ask the question, when we use all this water for rice and we export rice out of the Colorado River Basin, we are exporting our water. So yeah, oftentimes you really can't argue, well, in agriculture, we're always reusing it. No, we aren't. We're exporting it in those crops. So when we grow cotton and we use groundwater to irrigate it, we are exporting our groundwater in that cotton. So interesting question. If we, let's say, produce bottled water, we're exporting that water. So it's when you really think about it and you really look at this, it's called oftentimes virtual water. And there are websites that you can go to that if you want to produce a bushel of corn, it will tell you how much water it really takes. If you want to find out how much it takes to produce a barrel of beer, you can go to those websites. And I've oftentimes sent people information on that. So Larry, I see you're typing something. Obviously, I've been stimulating a thought in your mind. Uh, the question, is it reused? Well, I guess if we eat corn, we're using it, and some of it may come out, but it's probably not being reused. Now, in the oil and gas industry, and Larry raises a good point, when we pump this water into these formations to break them apart, some of that water comes back up to us, but it comes up contaminated. And so what the oil and gas industry does is we take that fresh water, put it into the ground, frack these formations, and then it comes back up, but it's contaminated. And so we've got a couple of options. We can put it on the ground and let it evaporate and then end up with contaminated soil, or we can take that produced water, and that's what it's called, produced water. We can re-inject it into the ground in formations where it won't contaminate potable groundwater, or we can clean it up. And we have faculty members here at Texas A&M that are looking for different ways to clean up water once it's produced. The other option, and the oil and gas industry is experimenting with this, and hopefully over the next 5, 6, 8 to 10 years, we'll be able to use what's called brackish groundwater that's too salty to use for drinking or for crops. We'll use that water to frack, that way, thereby saving very precious potable groundwater. Okay, let me talk now more specifically about the four categories of water in Texas. Natural surface water. Today we operate, this water is owned by the state and it allocates it under a doctrine called prior appropriation. What this doctrine basically means is if we get into a shortage, we don't share and share alike. We don't let cities have first priority. We award that water to senior water rights holders. If you used it first, you get to use the full amount that you've used, then the next person in line, the next person. Ultimately, we get to a point where all these senior appropriators have used all the water and there's no water left for anyone else. And that's the rule that we operate under today. For groundwater, groundwater is privately owned. When it's below your property, you have a private property right in that groundwater, and that is subject to the rule of capture, which means your neighbor, if they put in a deeper well and that water migrates from your land to their property and their well, they can capture it. And it's also subject to the rules and regulations of groundwater conservation districts. So diffuse surface water, this is the water that falls as rain or snow on your land. It's yours to use so long as it doesn't flow into a river, a stream, a creek, a slough, a ravine. When it flows into one of these, that water is transformed from your private property to property of the state. The underflow of streams deal with these aquifers that are closely connected with rivers. And our Texas statute says, as part of our water code, the underflow of streams belongs to the state and is subject to private rules, except that this statute doesn't really define underflow of streams very well. So let me talk about this state-owned surface water. Interestingly, in Texas, we've gone through an evolution. We know that Spain and Mexico had jurisdiction in this state. In 1840, our Republic of Texas legislature said, we're no longer going to follow the laws of Mexico. The laws of Mexico and Spain said, when you look to your original land grant, if you had a grant that granted you property that touched the river, you didn't have the right to use water from that river unless that grant gave you a water right. In 1840, then, our legislature adopted this riparian water right system, this English common law, which we followed in this state till about 1915. If you think about land grants in Texas, most of our land was publicly owned in the 1840s. So by the turn of the century, 1915, most of this land had been conveyed to private parties, and it carried with it riparian water rights, which gave you the right to use water from a river, provided your property touched the river. After the drought of the 1950s, all of these earlier acts did not abolish riparian law. They didn't abolish the law of Mexico or Spain with respect to water. And so when our legislature said, we've got to unify all of our water system to have one system, the legislature passed this Water Rights Adjudication Act of 1967. And what this act basically said is, if you're claiming water based on the law of Spain or Mexico or riparian water law, or you had a permit under these earlier statutes, you have a certain period of time to come before the Texas Water Commission, demonstrate how much water you're using, and the Water Commission will go through the entire river basin and look at seniority and come up with a permit that will give you a water permit as of time. And so the Water Rights Adjudication Act required everyone to do this. If you didn't do this, then your water rights, if you held any water right, you no longer had the right under that system. So we converted everything to this prior appropriation doctrine. And the Water Commission, now TCEQ, went through all our river basins and allocated water. As a result, 12 of our 15 river basins are fully spoken for, and there's no more water available. So this water in water courses, the ordinary flow, the underflow, the tides, stormwater, floodwater, or springs that pop up in our rivers, all of that belongs to the state, and the Texas Commission on Environmental Quality issues permits to use that water. So here's the reality in Texas, ladies and gentlemen. Almost all of our surface water in this state is fully spoken for. So we've got some 6,500 water rights permit holders, but 90% of all the surface water in this state is held by about 200 water rights holders. So today, if you want a water right, you buy it from someone else. You can apply for a water right, but you will be junior in time. So if we're in a drought, any water rights you apply for today, all these people who had rights before you get to fully exercise your right before you can use water. So you might have a paper water right. You get dry water, no wet water during times of drought. So you can buy someone else's water, and you can buy their priority in time. So that's the opportunity today as we look forward, is marketing of surface water rights. And indeed, river authorities do this. They authorize the sale or lease of water to municipalities and landowners. So this, looking just at the Trinity River, for example, and I have a list of all of our 15 river basins. If any of you want this list of who owns these top 10 water rights holders, you can send me an email and I'll email you this list. But if you just look at the Trinity River, the city of Dallas is the biggest water rights holder on that river. When you look at these 10 different water rights holders and you look at the total amount, and there are 530 water rights holders in the Trinity Basin, these 10 control 91% of the water allocated in that basin. So when you look statewide, river basin by river basin, and I've calculated this, you can find the top water rights holders in every river basin. So if you want to get a water right today, there has to be water available. You have to use it beneficially. So these are all the criteria that you have to satisfy. Here is the takeaway lesson from our surface water permit system. When there's plenty of water for everyone, this system just operates in the background. Everyone gets to use the water from the system. But when we're in drought and there's not enough water for everyone, we operate on first in time, first in right, or seniority. This became very apparent 2 years ago in the Brazos River when senior water rights holders made what's called a call on the river, and TCQ sent letters to people on the river saying the more senior water rights holders, there's not enough water for everyone, you have to stop using water to allow the more senior water rights holders to claim a water right. So here's an important point I want to make that's oftentimes lost. Recognizing the legislature still wanted to have some aspect of riparian water rights, the legislature in our water code created what's called a stock tank exception. And this exception allows, you don't have to apply for a permit to TCQ to get this. You can impound up to 200 acre feet of water from a river or stream that's state water without getting a permit. You can pump it from a river and put it in your own stock tank, provided you use it for domestic and livestock purposes. So it's a recognition that domestic water use is so critical that we're going to allow people whose property touches a river. You have to have property that physically touches it. You can take up to 200 acre feet of that without getting a permit, provided you use it for domestic livestock. And the legislature added wildlife and fishing, but you can't use it for commercial operations. If you want to use more, if you want to change your use, then you have to apply for a permit, and you'll be oftentimes lowest in title. I want to make a point here. This is state water. When we get to diffuse surface water, this 200 acre foot does not apply. Now, I recently asked the staff at TCQ, if you own property, are you limited to 200 acre feet? And what they have said to me is, no, you can have multiple ponds on your property. Each pond cannot exceed more than 200 acre feet. So you could have 10 ponds that hold each pond 199 acre feet of water. So this is a little different twist. And as we get drier, but each one of these, you can only use it for domestic livestock, wildlife, or fishing purposes. These are some critical issues. I'm going to pass over these to get to, because we're limited on time, the diffuse surface water. This is rain that's on your land, ladies and gentlemen. When it's on your land, if it's not in a water course, it's your private property. So you own the rain. Except if you go in Colorado, you must apply to the state for a permit to capture and store this water. They're the only state in the nation that does it. So when it's on your land, if it percolates into the ground, it's your private property. The stock tank exception that I just talked about does not apply. So if you capture this diffuse surface water that's flowing across your land and you capture it all, you can capture more than 200 acre feet. If your neighbor downhill who relies on this if you capture all of the water, your neighbor doesn't have a remedy against you. So you can either be a good neighbor or a bad neighbor, depending on how much water you capture. I want to talk about Texas groundwater because this has really been the hot button issue over the last 10 to 15 years in Texas. So this is water that's beneath your land surface. If it makes it under the surface, you have private property rights in it. So our Texas Supreme Court, starting in 1904 in the East case, they reaffirmed this in 1999 in the Cipriano case, and most recently in a lawsuit titled EAA versus Day, the Supreme Court of Texas again said, and here's the important point, in the Day case, the court said, you have a private property right in the water underneath your property. You don't have to capture it before you get this private property right. But this private property right is subject to the rule of capture, and it's subject to the rules of groundwater conservation districts. So if you look to this rule of capture, and this rule really deals with disputes between landowners. So I call it the biggest pump. If you have a pump under your property and you pump water and water from your neighbor's land migrates to your well, you can pump this without liability to your harm to surrounding neighbors, provided you don't do it with malice, you don't do it with willful intent, you don't waste that groundwater, or you don't cause their property to subside. So landowner rights under the rule of capture, they're pretty extensive. It's much like free market rights. These are some of the consequences of the capture rule. So there's limited protection for other landowners. It's the rule of the biggest pump. We can have groundwater mining under this. It allows people who pull up water, you can sell it if you're under the capture rule to whomever you want. There's really no incentive to conserve, because if one neighbor conserves and another doesn't and they pump it up, they're really pumping water you've conserved. And clearly the capture rule, we've seen cities operating under this rule to go into rural areas to put in wells and pump water to cities. And so over the last 20 to 25 years, we've seen extensive efforts for water marketing. So here's the rule on groundwater in Texas. We have the capture rule, but these are the judicial exceptions. You can't do it to harm your neighbor. You can't waste it. You can't pump so much water so that the land subsides, and you can't drill a slant well under your neighbor's property. The legislative exceptions, the groundwater that's connected to a river, the state can regulate that. Water pumped by the Edwards Aquifer Authority, only in the Edwards Aquifer, they can regulate that. And the Supreme Court in Day said, two exceptions. Groundwater is subject to the rule of capture and to the regulations of groundwater conservation districts. So in this case of the Edwards Aquifer versus Day decided in 2012, here is the significant part. The Supreme Court of Texas said property owners have a right to the groundwater beneath their land. They have a property right. And this property right is a limitation on the power of groundwater conservation districts to regulate pumping. It's this groundwater right that you have are subject to constitutional protections against takings. But it doesn't mean groundwater districts can't regulate and put some limitations on your property. So what the court said, there's some other provisions, lots of interesting issues in this Day case. So you have a private property right. It's subject to protections against government, but under the rule of capture, your neighbors can capture this and you don't have a right to recover except we're in one of these waste or malice. But here's the interesting thing. If you sue a groundwater district and you don't win, the groundwater district wins, you must pay their attorney's fees. And so the Supreme Court of Texas upheld the constitutionality of loser pay. So if you as the landowner, you want to sue a groundwater district because they've restricted, if the court doesn't agree that this has been a taking of your property, then you will pay not only your attorney's fees, but theirs. The Bragg case decided in 2013, again, suing the Edwards. The important point of this Bragg case is the Court of Appeals said the rules of the Edwards Aquifer Authority have deprived the Braggs of a private property right. So this case is on appeal, but the takeaway message from this, and I could spend an hour talking about the consequences, is the measure of damages. What the court said is the measure of damages that the Braggs could recover was the value of their land with water rights before the regulation, and then the water or the value of their land after the regulation. Part of that time, the Braggs had said, no, the measure should be if we have to go buy water at $5,500 an acre foot, we ought to be compensated for that. And the Court of Appeals said, no, it's a before the rules and immediately after rules. That's how you measure damages. So today we've got some 99 groundwater conservation districts, and these districts can impose regulations on spacing and the amount of water that you can pump. However, you can sue these districts if you believe there's been an unconstitutional takings. The statute allows people to pump up to 25,000 gallons a day without getting a permit, provided you use it for domestic and livestock purposes. And these cite some of the advantages of groundwater districts, some of the disadvantages of groundwater districts, coverage of groundwater districts in Texas, and my concluding observations. We know in the hydrologic cycle all water is connected, but our Texas law recognizes three categories of water. Surface water in rivers and streams, we've long accepted that as belonging to the state, and the state allocates it. Groundwater is private property. Groundwater districts can impose different rules. They can have the rule of capture, reasonable use, correlative rights. They can put a variety of pumping restrictions. And what we're going to clearly see is more litigation. So we have sort of come to the end of this period. I will stay online for those of you who want to stay connected on the webinar. Pete, I don't know if you automatically bump them out, but I'll entertain questions.
No, sir, I won't bump them up. I'll have some final thoughts after you answer the questions. So, but anyway, let me go ahead. We got quite a few questions that were typed in. Let me just go read down the list. Scott asks, what designates a stream or a creek? Mine are dry at least half the time.
You know, the definition of a water course, it has a bed and banks. So in some appeals court decisions on very small, where the river may be dry half of the year, and when the water flows off your land and is flowing in that area, if TCEQ wants to take a very expansive view, they can claim that water as state water. So there's a lot of ambiguity in that water, and particularly in these ravines in areas of Texas where there's only water when it rains. But the rule on a water course is if it had a bed, in other words, it has a bottom and side banks on it that really contain it or restrict it, that's a water course. And so I guess part of it is the level of policing that TCEQ wants to do on that water. But looking at the statute, this is flood water or storm water that flows into these water courses. That's state water.
Tom asked the question, is there a viable market for groundwater sales?
For groundwater sales?
Yes, sir.
Yes, there is. It tends to be a two-party. Well, the interesting phenomenon, there are private interests that are out acquiring groundwater rights from private landowners. They act as water brokers. And so these water brokers have made investments. They're leasing land for groundwater rights under that. And then these entities are trying to then find customers for that. The second pattern, cities water suppliers are going out and negotiating directly with landowners to acquire groundwater rights. And so most of this activity is really in three areas of Texas. It's along the I-35 corridor. It's clearly out in far west Texas around El Paso, and then it's up in the Panhandle. There's an entity up there called the Canadian River Municipal Water Authority that has bought the water rights from T. Boone Pickens and his partners. Plus, they have acquired water rights from many landowners. They have spent over $100 million to acquire groundwater rights to provide water to these 11 Texas cities that are part of their consortium.
Sarah's question is, are there fees associated with groundwater withdrawals?
Basically, if you've got a groundwater district, that we have two kinds of districts supported by property taxes and districts supported by user fees. So if you happen to be within a groundwater district that's a fee-based district, in its fee-based, you will pay a fee for the application to pump water plus an annual fee to use water. And it varies from district to district.
Bob's question is, can you give us a brief description of what a river basin includes?
A river basin would include, if you think about sort of the continental divides of the United States, water east of the continental divide on the Rio Grande, for example, it's all on the eastern side. So it's all these streams that feed into it. In Texas, if we looked at our 15 major river basins, these are really areas that all these major little creeks and all the surface drainage flows into that. There will be a point where elevationally it doesn't flow into the Brazos, it will flow into the Colorado. So a basin really captures all the surface water flow in that basin.
Joel's the question is, what is the status and what are the rules regarding the many 20-acre or so conservation reserves, lakes around the state?
That's a good question. You know, federal law, these old 566, these reservoirs where USDA provided funds to build these stock tanks. The rule, again, is if you impound less than 200 acre feet, you can build that stock tank. It's state water. So you impound it on a water course that the water would belong to the state. Provided you use that for domestic and livestock purposes, you can construct those. But here's the interesting question. It's all about rainwater harvesting, isn't it? And it depends where we want to harvest that rainfall. We can do it at our household level and put it in rain barrels. We can build rain gardens. If we have property, we can capture it in ponds. Or ultimately, the ultimate rainwater harvesting are our reservoirs. So there are some estimates that as we built all these stock tanks and ponds in Texas, we have captured up to 20% of the stormwater that would otherwise flow into our rivers and reservoirs by these stock tanks. But the Texas legislature has clearly granted this privilege.
Billy Howes, I guess his comment to one of your comments, except that TCEQ didn't strictly follow first in time, first in right. They exempt some junior water rights holders from that order.
I think Billy, and hello, Billy. Billy is familiar with this case on the Brazos River, where when the TCEQ issued a call on the river, they argued, and ultimately they, being TCEQ, lost this case at the trial level. What they told many senior water rights holders is they had to stop pumping so water could be used by cities and some industry at the bottom of the basin. They were relying on an ambiguous part of Texas law for that proposition. I believe the correct rule, and that was the rule at the trial court, when we're in a drought, seniority is the rule that governs the allocation. Now, the legislature can change that, but it will change it with some risk for depriving people of private property rights. So on the Brazos River, the TCEQ tried that. The trial court rebuffed that, and I think the trial court was correct.
John LaRoche asks, what is a water course reference diffused water?
And we're back to this. A water course has a bed and banks, so it doesn't have to have water in it all the time. It's the stormwater that flows on your land. So long as it's flowing in an unpatterned way, it's your private property. If you have a gully or a slough or a stream that goes through your property or a creek, when the water flows into that creek, it's state water.
Vivian asks, I thought there is a minimum 1 acre size required for water wells. Have a lot inside Houston, but no public water. So can I just put in a water well?
That's a good question. Here's the point. Groundwater conservation districts can impose well spacing. Also, cities can impose requirements under their charter, under ordinances that allow you to drill for groundwater in your city, or they can impose restrictions. But here's the interesting phenomenon, and I know some cities have changed their rules, because if you look at the ruling of the Day case and you look at the ruling of Bragg, some would argue that within a city, I have a right to put in a well to use water for domestic and livestock purposes. A blanket city rule that denies me that right, that person can always argue that's a takings. A number of cities have decided we don't want to fight that battle for all landowners. So there you have changed the rule to allow anyone to put in a water well in their city for domestic purposes. Some cities still will hold to a requirement that you can't put in well, you have to buy the water from the city water system. So this is an evolving area. I guess I would say to the homeowner that's thinking about this, if you sue a groundwater district because of this and you lose, you will pay not only your attorney's fees, but the groundwater district fees as well. So stay tuned. This is really an evolving area in urban areas. Now, for College Station, for example, we're pumping water from 2,000 feet down. Very few landowners can afford the expense of drilling a well that deep. So in many ways, there's not a big impact on landowners really depriving city of groundwater.
The next question, Deanne says, what rights do the oil and gas companies have over landowners' water who have no minerals interests?
Well, again, it's the rule of capture. So let's say an oil and gas industry or a company leased water rights from one property owner and they didn't from the neighbor, and they put in a well, and that water migrates from under the landowner that didn't lease. It goes to the well put in by the oil and gas. What the court has said is we follow the rule of capture. So if they're doing the oil and gas well, that they're pumping that fresh water for fracking, if they're doing it not to harm the other side, they're not wasting it, it's the rule of capture.
Okay, I'm gonna skip over Billy's. Billy comments to Vivian says sometimes cities have ordinance on drilling wells. Also, Houston's in the Harris County district, they may have a rule on minimum acreage. So I guess you're replying to Vivian.
Right.
Big question is, how about natural springs that eventually run into a watershed?
Good question. Based on some prior appellate court cases, and they're really interesting, if you're a landowner and you know you have a spring on your land that eventually is bubbling out of the bank and going into a river, if you put in a water well 10 feet from where it bubbles in, comes to the surface, and you intercept all that water to dry up that spring, you have a right to do that, because that, so long as that water is under your land, that is your private property. The minute it flows into the river, it belongs to the state, and if you want to use it, you must get a permit from the state to use that water, or Or if you're using it for domestic and livestock, you can use up to 200 acre feet of that water.
Jennifer's asked is, how will the federal ruling on the definition of water of the U.S. impact water resource management in Texas and in other nations?
That's an interesting question that's generated a lot of controversy, and it deals with cases involving wetlands, a provision of the Clean Water Act called Section 404. The question is where we've got wetlands that are some distance from a river, a lake, river, or stream that's navigable. The Clean Water Act says the navigable waters of the United States. The Supreme Court of the United States has tried to define some of these areas, and there's so much confusion on which member of the this is the U.S. Supreme Court, which decision you want to follow. So the EPA and the Corps of Engineers have tried to write some definitions as they've looked at these rules from the Supreme Court to bring about a unified set of rules. Well, this has generated all kinds of folks, all kinds of interest from people from rural areas. It is significant, but there's a tremendous amount of misinformation out there about this. Now, these rules are always subject to challenge. So what these rules will do is try to bring some certainty, but they're always subject to challenge and to be reviewed by the court for adequacy.
Jerry's question is yard watering the biggest culprit of water misuse?
Not sometimes, yes. When we look at overwatering, and so we've argued in our research in College Station has said for people with big yards, if you want to do that, because College Station has a block grant pricing, so the more water you use, the more you pay for it, and the higher the price. So our research in College Station said overwatering comes from people running their irrigation system after it's rained and you don't need to water. It comes from running their irrigation system too long. It comes from leaks, from broken sprinkler heads, from improper slope. So the target in College Station is to tell people only provide that amount of water that the lawn really needs that rain doesn't provide. So we've found that there's significant overwatering of lawns. There is also significant overwatering by farmers, but farmers don't want to put in meters. And so the real challenge in this state, and this is what we found in the Panhandle, when groundwater districts have moved to requiring farmers to install meters, farmers oppose this dramatically, but city users have meters. So if we're going to manage this state on fairness, ultimately we're going to have meters to monitor to make sure people aren't using more than they should use.
Rick's question is, hasn't the federal government defined streams and waterways?
The federal government has said navigable waterways, and I could spend an hour just talking about federal definitions of navigable waterways and navigable waterways under state law. So sometimes if they're not navigable for federal purposes, in Texas, we have definitions that are more expansive than the federal definitions for defining a navigable waterway.
Wesley asks, what's your opinion on crops like corn which demand lots of water being grown in the Panhandle? Are genetics or conservation a better option?
You know, we can always look for improvements. I think one of the things that if we talk about freedom, that farmers have the freedom to plant anything they want, provided it's legal, if they can pay for it and they get a rate of return. We probably are not going to see the day where farmers are told what they should apply, but in other countries, we clearly do that, where people try to plant high water use crops in an area where they shouldn't. So that's a real interesting question. Clearly, in this country, we are trying to grow crops in areas where we're water short and we're pumping water out of the ground. Clearly, we're mining groundwater. But again, part of this is the ability for landowners to be able to do that.
Paul's question is where would I find the state definition of navigable waterways?
I'll give you two real simple ones. A waterway in Texas is navigable if it supports commercial uses. So if you can show that there's a barge on it, if you've had shipping traffic on it, the Brazos River, for example, we had steamships that came all the way up to Hearne, Texas. They may have gone up as far as the falls at Marlin. The Brazos is clearly navigable. And so it's if you had commercial enterprise, or you could float logs down it, or you use it for some commercial enterprise. The second test is if our rivers, if you measure its width, the courts have recognized any river, and the legislature imposed this rule, any river that averages 30 feet in width from the mouth on up, that is a navigable river. Let's say it holds water only for 3, 4, 5 months of the year, or water is only 1 or 2 inches. If it meets that 30-foot test, it's a navigable waterway.
Joel's question, collecting rainwater with a terraced pond subject to 200-acre foot rule or a limited pond size?
It all depends on whether the capturing mechanism, if it's a terraced pond and it's capturing diffuse surface water, there is no limit on the amount of water that you can capture. If it's water in a water course, your pond that on that water course can't exceed 200 acre feet. And that's just the pond, and you have to use water for domestic and livestock. For diffuse surface water, you can use it for whatever you want.
Don's question is, I live in a rural area and have a well for domestic use which is drying up. The land is my property line. Can I pump out of it under the 200 acre feet exception? No permit required?
That's a good question. If Don's property touches the Llano River and he is a riparian owner, Don can take up to 200 acre feet of water out of the river, provided it's used for domestic and livestock purposes. If his well is pumping, if he's got a water well, then it's groundwater. The only exception is if he's pumping the underflow of a river, and then it's an interesting question. If it's the underflow of a river and he's using it for domestic, Don could argue whether it's surface water or groundwater, I still have an exemption for this well. That would be really an interesting question.
And I guess Joel's comment is that 200 acre feet per year?
No, that's the total storage capacity of that reservoir. So it may be at times 199 acre feet or 200 acre feet. The legislation allows for you to capture more of that if you get a big flow, but on average, it's not more than 200 acre feet. Now, keep in mind, if you own large property, you can have 20 different ponds that all hold 200 acre feet of water.
Don's question is, how do I know if I have the riparian right?
If your property touches a watershed, even though you didn't apply for a permit under this Water Rights Adjudication Act, as a riparian water rights holder, if you have the right and your property runs down to that navigable river, you are a riparian water rights holder. Now it's possible, let's say you bought that property and the person who sold it to you said, oh, I'm carving out 10 feet from the river an easement. And so that easement is my property line. Even though your property comes close, it has to physically touch the watershed.
It looks like we have one more question coming up. And while Richard types his question, let me go ahead and make a push for our next upcoming webinar. Our next webinar is going to be on June the 5th at noon, Texas time, and it's going to be herbicides used near water. and Mark Marshall is going to be a presenter. And you can also follow us on Facebook and on our website. And the question from Richard is, are the reservoirs the same as rivers?
No, reservoirs, think of a dam, think of anything that blocks the flow of water and stores water on a river. So when I talk about a reservoir, we're talking about the water body behind a dam.
Yes, and this question was asked earlier. Is it okay if they get a copy of the PowerPoint?
Pete, what I'd like you to do is convert that to a PDF,
Yes,
and
sir.
you can send out a PDF. That way, if they pull anything from it, I'd like recognition or acknowledgement.
Okay, so in that case, if let me say this, if you want a copy of the PDF file, type in your email address on the chat pod, and I will capture those, and I will send you the PDF file. I guess Howard has a question. Riparian rights same for reservoir and river property owners?
Let's see. Is this Joel or who is this?
Yes, it's Joe, and I kind of
Is the reservoir treated the same? No, Joel, that's an interesting question. This is one of the nuances of Texas law. There are two kinds of rights called there's one right called run of the river right. So if you're a riparian water owner, landowner, so long as the river's flowing, you have a riparian right. However, if you are on a reservoir, the owner of that reservoir has applied for a right from the state to capture that stormwater. That stormwater that they've captured is their property. Now, what's occurring throughout Texas, particularly as we get into droughts, many people own property on reservoirs. So if you own property, let's say at Lake Conroe or Lake Livingston, or some of the reservoirs, Canyon Lake by Guadalupe Blanco River Authority, or some of the reservoirs of the Brazos River Authority, that is their water. And you could then potentially pump some of that water out, provided it matches the flow of water coming into that. But if there's no water coming in, all of that water belongs to the owner of that reservoir, and you would have to get permission from them to pump some of that water.
It seems like folks are typing in their email address, and Dr. Kaiser, I'll go ahead and then send them the PDF file that you sent me. I'll send that to them if that's okay, and I'll CC you on the email whenever I send it out.
Okay, thank you. I'd appreciate that. And if folks have, I have a really busy schedule for the next month and a half, actually for the next 7 months. When I finish here in College Station, I will be taking graduate students on a 2-week field trip on the Rio Grande from the headwaters all the way to the Gulf. I come back for a week, and then I will be in Colorado until probably December doing some research.
Most of the folks should have gotten the question here. Please fill it out. It'll help us improve our webinars. Dr. Kaiser, and this is awesome information, and the recording should be up on the Natural Resource webinar range page tomorrow.
All right, Pete. Well, thank you very much. This is the first one I've done with which doesn't have a video component, so it was kind of interesting. And thank you to you for helping someone who's technologically challenged on this work his way through it. And so it's